Be ready. 5 seconds.
Learned counsel appearing on behalf of the appellant submitted that the charges framed against the appellant have not been duly proved by the prosecution against the appellant. Stop. The evidence is not reliable and does not inspire confidence, and thus the impugned judgment and order on sentence be set aside and the appellant be acquitted. Stop. It was contended that the prosecution had built up a false case by introducing an informer in its story who was neither cited nor produced as a witness in the court, and therefore, such evidence is neither admissible nor reliable and is liable to be discarded. Stop para. It was submitted that the accused was arrested from outside his house and was taken to office of crime branch where he was subjected to third degree, which can also be confirmed from the TV channel footage of the press conference. Stop. Despite the alleged place of the appellant being heavily inhabited, nobody was called from the neighborhood to witness the proceedings. Stop. It was further contended that the TIA phone shown to have been recovered from the appellant was planted on him and was never actually recovered from him. Stop. Further, neither the said phone was identified from the person who claimed to have sold it, nor any bill of purchase/sale of the same was brought on record. Stop. It was further contended that the recovery of dead body at the instance of the appellant is not proved, and the story of prosecution in this regard is unreliable. Stop. It was further submitted that the place of recovery of dead body was already known to the police and that the police itself got the body recovered in the absence of the appellant. Stop para. The prosecution also relies upon the last seen evidence in the form of testimony of PW34, who was a property dealer and who stated to have seen the deceased child sitting in the car of the appellant. Stop. It was submitted that there was significant improvement in his version as narrated to the police in his statement under section 161 of the Code of Criminal Procedure, 1973, and as stated before the court, which renders his version unbelievable. Stop. In this regard, reliance was placed on the decision reported as AIR 2008 SC 114 Satish Rajanna versus State of Maharashtra. Stop. It was also pointed out that no application for getting the appellant identified was moved, and therefore, in the absence of identification of the appellant renders the evidence weak. Stop para. As noted above, from the facts of the case, it is evident that the father of the appellant was in debt and besides he himself owed money. Stop. There is no previous criminal history either of the appellant or his family members. Stop para. Thus, in view of the settled principles of law, this court comes to the conclusion that this case does not fall in the category of single quote rarest of rare cases. Quote close. Stop. It is not a case where reformation of the appellant is not possible, and accordingly, this court is of the considered view that sentence of imprisonment of life with no remission till 20 years would be the appropriate sentence. Stop. The sentence of the appellant is thus modified to rigorous imprisonment for life with no remission till 20 years, and to pay a fine of rupees 1 lakh, in default whereof, to undergo simple imprisonment for 6 months for offence punishable under section 302 IPC. Stop.